Hello neighbor, I'm Robert Burns and welcome back to another edition of Sound Off Louisiana, and we have a ton of material to cover, so we're going to cover it fairly quickly. My guest once again is Billy Broussard, and our goal today is to bring everyone up to speed on his two defamation lawsuits, one against Melissa Dubrock and Minnie Gerard, the other against Scott Lopez. Now, you will recall from the last feature we did, Mr. Broussard had a peremptory exception or no cause of action hearing that was conducted on February the 15th. That involves the Gerard / Dubrock litigation. At the most immediate after ramification from that was that Mr. Broussard filed a motion to recuse Judge Bourne. And let me just very briefly say, as most of you know, I spend an ungodly amount of time in courtrooms. I know I can safely say that I have sat in on it no less than 700 peremptory exceptions, no cause of action. And I know I'm being conservative. And I'm just going to say this. Judge Bourne exhibited the worst courtroom mannerisms I have ever witnessed in all of the court hearings I've attended, and that's a lot. And as a result of that, Mr. Broussard and his belief that Judge Bourne was clearly biased against him, I'll let you be the judge of that in looking at the transcript. But at any rate, what prompted it was Judge Bourne's repeated emphatic statements 5 or 6 times that he was going to assess Mr. Broussard with attorney fees if he dared to amend the petition, and then the exception got re-urged and it was deemed that he did not cure it. What happens when you do that, the Louisiana Supreme Court, well, first of all, Judge Bourne could have voluntarily recused himself. He did not opt to go that route. And so accordingly, the matter had to be submitted to the Louisiana Supreme Court. The Chief Justice there assigned Judge Walter Lanier, who is a judge on the First Circuit Court of Appeals, to oversee the hearing on the motion to recuse. And while the motion to recuse was denied, it was noteworthy that Judge Lanier used the word artful to describe Judge Bourne's wording with regard to the potential for the assessment of the attorney's fees. He also said because that is a contingent event, he or the court could not consider that in making the decision of whether or not to recuse. He could only look at what happened that day, February 15th. But in choosing the word artful, we can give you a number of synonyms: dishonest, underhanded, scheming. They were all added to the final judgment, or at least Mr. Broussard wanted them added, and he put that added wording for what the word artful means. But with regard to the contingent event, that pretty well meant that he was not going to be able to grant the motion to recuse. I kind of read into that if Judge Bourne had assessed attorney fees, he probably would have granted the motion to recuse. But be that as it may, Mr. Broussard made a conscious decision that he did not want to proceed forward with that case, given that he was going to be having to appear before Judge Bourne. And so what he did on March the 30th, actually March the 29th, he sent notice because Judge Bourne's office was wanting to know, okay, where does everything stand? And on March the 29th, Mr. Broussard communicated that he was working on something that may negate the need for any of the hearings. He drafted an email to Judge Hike which said, look, I'm willing to voluntarily dismiss this, each party to bear their own cost. That was going to be a non-starter because there was no way that they were going to agree to pay their own. Now, when we say cost, we mean court costs. For those of you who don't regularly go to court hearings or are not attorneys, any attorney is going to know what that means. That means court cost. It does not mean attorney's fees, okay? And so Mr. Hike kind of, yeah, okay, I'll present that to my clients, yada, yada. Well, the next day, Mr. Broussard went ahead and hit him with the atomic bomb, if you will. He said, here, I've drafted an order for this to be dismissed with prejudice, which means you cannot bring it back. to dismiss this with prejudice at plaintiff's cost. And every judge knows what that means. That means, hey, common sense tells you I got to pay my own court cost, but he's saying I will pay defendant's court cost. Mr. Broussard then took that order into the clerk of court's office on March the 30th. When he presented it to them, they said, all right, if you want this matter dismissed, let's give you the court cost figure. It was approximately $1,251. We're going to give you a receipt for it. Mr. Broussard pulled out his credit card. They swiped it. They gave him the receipt, and they said this matter is dismissed. And they so noted it on the docket for April the 2nd. And it was so noted, we're going to give you the actual docket. It says it is dismissed. Nevertheless, that got Eric Hike's attention. And so he scrambled together on March the 30th and threw together a very quick expedited hearing for a motion for sanctions under 863. 863, Code of Civil Procedure 863 basically is an assertion that the entire lawsuit was frivolous and had no basis. I can only state that I was quite shocked, and I told Mr. Broussard from the outset of the litigation, I said, look, there is no way that Eric Hike is going to fail to assert Code of Civil Procedure 971, which is a special motion to strike, and that is a code that does have a provision for recovering attorney's fees. Here's the deal. You only have 90 days to file that from service. I thought he would be filing it for both of the two lawsuits, as well as I thought the newspaper would be filing a 971 motion. I'm very familiar with 971, for one, because it's been asserted on cases that I have sat in and reported on, namely Murphy Painter, but also it's been asserted against me twice personally, both times by the Auctioneer Licensing Board. Both times they failed. The judge said I was not a public figure just because I was an auctioneer. But anyway, for that reason, I was extremely familiar with 971, and I was quite stunned when 90 days went by and Eric Hike never asserted 971. The matter, the clerk said this matter's dismissed. They closed it out. Then Eric Hike comes in the next day, the same day, March 30th, files this motion for expedited hearing on 863, even put in there support memorandum to follow. And he filed the support memorandum. Now, bear in mind, this is all for a hearing that they want to take place on April the 3rd, which was the Monday, the following Monday. Saturday was the 1st, Sunday was the 2nd, Monday was the 3rd. So you can see what kind of you talk about the stick on it on dynamite. This doesn't have any fuse on it. It just explodes, all right? And so, Mr. Broussard, correct me if I'm wrong, but you opted not to attend that April the 3rd hearing. Is that correct?
Right, and I didn't just not on my own just say I'm not showing up. I first of all, when I went to the clerk of court that Thursday evening, said pay this amount, dismissed. Fine. So I said no more. This court hearing that's on the docket for that next Monday. He said no reason to come. The matter is closed. It's dismissed. So I said okay. So I even checked with them the Friday afternoon, late Friday, because the court would be that next Monday. So I'm just double checking to make sure that this docket, that is not on the docket. They said, they went and they pulled up the docket, said yes. They said, matter of fact, the money for the court costs is being sent to Hike, and the matter is dismissed, it's closed, and there's no reason for you to come to court Monday. So that, and it's all, it's on, I'm looking at the docket, it says dismissed. So I said, all right. Done deal. The whole, they said all we're waiting for now, judge just to sign it. And I think it was based on some CCP that he would be just signing it. So that's why I didn't show up for court, and I wasn't subpoenaed. There's no reason to show up.
You weren't served.
I wasn't served.
You weren't served.
I wasn't served to go to court. Plus the clerk of court saying no.
You don't have to go. Exactly. And I want to expand right there just a little bit. I neglected to say early on that February 15th peremptory exception, I talked about Judge Bourne's demeanor, his words. It's why I'm a big advocate for cameras in the courtroom. And I'm just going to say very briefly, not to get off on a sidetrack, I know of one candidate for governor who has strongly supported that, and that is Stephen Wagasback. On that, I strongly agree with him. I'm not making a full-on endorsement right now, but I just wanted to say that we need cameras in courtrooms, period. Because even with the transcript, I realized once that judge ordered 8 words, normally what I do is I bring my notepad and I take notes. After I heard the first 8 words come out of that judge, I threw my notepad to the side because I don't need to take any notes for this because I will be getting a transcript. I did. We've got the transcript. We're going to give you the link for it. And also, with regard to that April the 3rd, April the 3rd, I requested that. I went to it. I said, hey, I guess I'm kind of addicted to courtrooms, especially when it was under circumstances like this. And so I went to it and I observed it, but I never want to misquote a judge, so I requested that transcript. That came in yesterday. The day we are filming this is Saturday, April 15th, otherwise known as tax filing deadline. I was gracious enough to, Miss Mona Landry was gracious enough to get me the transcript yesterday, and I want to read what, I'm going to quote it verbatim as to why Judge Bourne says he did not sign the dismissal order. It says, I failed to sign it, hold on just one second. I failed to sign it because it delineated things other than just a dismissal. It delineated and directed the payment of costs by his own cost and whatnot. I don't know what you mean. I don't know what the judge means by whatnot. All I know is I've looked at the 2 orders that have been submitted. And by the way, Mr. Broussard submitted yet another order to dismiss that removed these so-called delineations, if you will. But with regard to the statement of and whatnot, both orders clearly said at plaintiff's cost. And every attorney who's passed the bar certainly should know what at plaintiff's cost means. It means Mr. Broussard would be paying obviously his own costs as well as defendants. He's just told you the clerk had him, well, he used a credit card, but he paid approximately $1,251, their court cost. So there shouldn't have been any confusion about, as he phrases it, as whatnot. At any rate, he made it clear he had not signed that order, Mr. Hike said, well, Your Honor, will you sign the order or the judgment pertaining to February 15th where you granted the first peremptory exception? And the judge said, no, I won't. He said, I'm going to wait until ultimately all of this, everything is when Mr. Broussard did not show up, which I think was a very wise move on his part because God only knows what would have happened if he had shown up. Everything is rescheduled for May the 23rd. But I do want to read one thing that Judge Hike had to say because I think it's noteworthy. And I'm going to read it as an entirety. It's one paragraph, but I want to take the time to read it directly from the transcript. It's at the bottom of page 5, top of page 6 for anybody who would like to follow along. So I'll reset all pending matters. His motion to dismiss and the terms under which it's dismissed, those are very clear at plaintiff's cost. Now, he didn't say that. I'm not reading from the transcript when I say it was made clear. The motion for sanctions and or attorney's fees will be set. I guess technically the motion to compel is set until the petition is dismissed and the motion for no cause of action. So all pending issues are going to be set and he'll be notified to be ready to address all pending litigation in this matter on that date by the next due date. And actually, let me read one more paragraph. Just for the record, it seems based upon the filing, the only issue that is contested is whether or not I grant, I'll say this on the record, I intend to assess all court costs to defendant. Well, I assume he misspoke on that. He meant to say plaintiff. It says defendant, but I will assume that that was an error or just a slip of the words there. I do intend to assess all your costs to the defendant. He clearly meant plaintiff. There is an issue of whether I assume what, if any, attorney's fees and what amount, if any. Twice in one sentence he used the words, if any. And all I can tell you is that is in stark contrast to what he said on February 15th. The man could not have been more emphatic. He said it 5 or 6 times. I will assess attorney's fees against you from the initial inception of the lawsuit through its conclusion. We actually covered this a little faster than I thought. I'm impressed. There are a few things that I could have gone into and not go into because I want to keep this short. But Mr. Broussard, hypothetically, if this hearing on May the 23rd, under 863, given all the circumstances that we've just laid out, well, let me say one thing first of all, and you can tell me if you agree, and then I'm going to ask you a question. What we have here is a situation where Mr. Broussard is very emphatic, correct me if I'm wrong, that you have no intention of paying any attorney's fees. No. All right, you just confirmed that. And I believe we have a situation, don't know it for sure because I'm not privy to their discussions, but I believe we have a situation where Ms. Gerard and Ms. Dubrock are also saying we're not settling this unless we get every dime in attorney's fees. Now, I could be wrong, but given that, that would seem, if that's an impasse that both parties remain at, and it sure sounds to me like that's probably where we're going to be. So next I want to set up a hypothetical. If we come to May the 23rd and the judge is inclined to, notwithstanding the fact that you file the motion to dismiss with prejudice at plaintiff's cost, and plaintiff has paid those costs, that plaintiff being you, what are your plans if he goes forward with 863 and you're assessed with the defendant's attorney's fees? What's your plan?
At this point, I will appeal it. I plan that is my full intent at this point is to appeal that. I'm not paying the attorney fees. And
I understand.
I believe that Third Circuit Court of Appeals will agree that they're not entitled to attorney fees.
Yeah, and the good part is the court costs for launching that appeal, and that's what you'd have to do is launch the appeal. They should be rather minimal because the 2 key elements that you need, which are the transcript from the February 15th hearing and also the transcript from this April 3rd hearing. Obviously, we'll get the transcript on May 23rd if that becomes necessary, but those are your key elements. And none of this took very much time. The transcript from February 15th cost $85. I paid it. I wanted the transcript. The transcript from April the 3rd was $65, and I paid it. So you're looking at what, I don't know, $150 or so. Not pretty good bargain considering what all is contained in those transcripts. So you're saying for the record that if you are assessed with the current attorney's fees, don't look for a check anytime soon because it will certainly be appealed. Correct?
Exactly. Correct.
All right, very good. Now, I want to move on and let's spend just a few minutes talking about a court hearing that you have at the date I'm filming this. It's 9 days away on April the 24th, and that entails the Lopez matter. And with regard to it, here we have another peremptory exception, and I'm a little shocked by this, but Mr. Hike has basically instructed Judge Pittman, who is the senior judge, that he needs to follow the lead of Judge Bourne. And yet it's Judge Pittman who had to box all this up, send it to the Louisiana Supreme Court, request the ad hoc judge. The ad hoc judge has said what he said, and yet Mr. Hike says you need to follow Judge Bourne's lead. I'm not sure how well that will go over with Judge Pittman, but since he opened that door, I noticed in your opposition memorandum, and I want to thank you for this. I'm flattered and I'm honored that you chose to put so much material from Sound Off Louisiana, specifically with regard to Murphy Painter. Most of the longtime subscribers know that is a 12-year legal battle, and Mr. Broussard has followed it religiously. And the other high-profile defamation suit being Corey Delahousse, and that's how you uncovered Sound Off Louisiana. But you referenced the September broadcast that we did where I wrapped up the Murphy Painter situation and the fact that Amy Groves Lowe and Preston Castile. Now, Preston Castile is no longer enrolled in the case, but he did the vast majority. He was the attorney for the vast majority of the time, and they did assert Code of Civil Procedure 971, and they did. I was there for that court hearing. I was there for every court hearing involving Murphy Painter, and there were at least 25 peremptory exceptions. And I love in there where you said, Mr. Hike must think that the state of Louisiana, specifically OIG, must be employing some boneheaded attorneys because they never once sought attorney's fees. Never one time. Wow, you reckon that might be because they're not attainable for the provisions of Article 9? I'm sorry, not 971, the peremptory exception. I believe that may be 934. Don't hold me to that. But at any rate, the point is, there's no provision for attorney's fees on there. And I'm sure that Amy Groves Lowe and Preston Castile, who are outstanding attorneys, and this is their area of expertise, okay? They defend state litigation where defamation has been alleged. Murphy Painter's not the only one. Corey Delahousse, you know, they know what they're doing. They know what they're doing, okay? And they successfully got 971. I've always assumed Eric Hike knows what he's doing, but I am at a loss for why he failed to file anything under Code of Civil Procedure 971. And I have to, just one second, I'm gonna let you talk. I have to wonder if he's now trying to clean up through this expedited hearing for 863, and the bar for 863 is far, far, far higher than it is for 971. And yet that's the route he's gone. You know, basically trying to do a cleanup, in my opinion, here. And I think the chances, let me put it this way, if this was seen before an impartial judge, and let's pray that, and I know you've said we need to pray for all judges, that certainly includes Judge Bourne, let's pray that there's a little bit more, in my opinion, impartiality shown on May the 23rd than there was back on February 15th. But that's where we are now. Do you have any thoughts on that, the fact that you're facing 863?
I just think the Ms. Gerard and Ms. Dubrock and the Lopez's probably have a bone to pick with Hike in regards to 971. So, but that's between them.
Yeah, right. That doesn't affect you.
That doesn't affect me. He had his time. And
he had the 90 days and he let it go.
For whatever reasons, he didn't know about it or he just didn't do it. But that's probably a question that they're going to have for him. That's between them.
That is between them. And I'll say this, I also felt like the newspaper, the Daily Iberian, I felt certain they were going to assert 971. But to my shock, they let 188 days go by where they didn't do anything. At least Lopez nor Dubrock / Gerard did that. At least they answered far sooner. So, folks, we were able to do this a little quicker than I thought. There may be a few things we left out. If so, I'll put them in the body of it. We're going to give you the high points from Mr. Broussard's most recent opposition memorandum, and we will certainly let you know how everything turns out after the April 24th hearing. So, Mr. Broussard, if you've got some concluding remarks you'd like to make, feel free.
All I'd like to say is like what I said to you before we went on camera, is that we have to pray for our law enforcement and our judges. I mean, Judge Bourne especially, I mean, he's a younger judge also, and you know, someone like Pittman, I was before Pittman, and I seen Judge Pittman doesn't allow attorneys to push him around, doesn't the pressure, but even I'm friends with judges, and they said, look, it's not easy being a judge. There's a lot of political pressure. I mean, we saw that article in Lake Charles where the judge said, I mean, he was just politically pressured by this attorney and ends up getting the judge in trouble. So I just, we gotta pray for our judges, and we gotta pray for the attorneys. And you know, politics is strong in Louisiana, and I think the political pressure that these attorneys put on these judges is just not fair to the judges. So we have to pray for them, and hopefully when this is said and done, I wish the best to Judge Bourne and his future. And I must say, Judge Lanier, he also a great judge. I'm
glad you said that.
Judge Lanier was a gentleman, very respectful.
Well, I don't have to say it now. You're saying it.
Right. I mean, I have to say, going before him, even though he didn't rule exactly in my favor, he pointed out the things. I had heartburn about something. He brought it out that it's not so much into the judge wouldn't be prejudiced from his judgment, but he pointed out that what was bothering me was the judge was being artful, so he did see that what was bothering me. He caught on to what was going on. But I have to say, we have to continue to pray for our judges and law enforcement, etc. So that's all. That's all.
Well, and I want to reiterate what he just said, because I'm being candid about this. Judge Lanier's demeanor, and to both parties, could not have been more professional, could not have been more respectful. He bent over backwards. I will say this because it just came to mind, and then we're going to wrap it up. But Judge Hike, I just elevated him there. Mr. Hike did put his foot in his mouth on one occasion in front of Judge Lanier, and we're getting that transcript too. I hope we have it before too long. But where Judge Hike, I've done it twice, where Eric Hike put his foot in his mouth is when he said, well, now, Your Honor, Judge Bourne has looked at these other defamation suits. And that's the one time Judge Lanier went ahead and cut him off. He said, no, counsel, I'm not interested in any other suit other than the one that is pending before me now. And then when Mr. Broussard was given a chance to reply to not just to that, but to other matters as well, Mr. Broussard did bring up the fact that he said, well, counsel has just stated that Judge Bourne looked at these other suits, and Judge Lanier said, yes, and I told him I'm not going to consider that. And Mr. Broussard said, well, the only thing I was going to say is that must infer there's been some ex parte communication. And I thought Billy, when I was sitting there, I said, you just hit that one right out of the park.
Yeah, I mean, I was never in part of any conversation where the judge was, talking about
your other suits. Exactly.
So how would he know what the judge?
Unless he has so much free time on his hand that he just pulls up various cases to look at them for the heck of it.
How would Judge Hike? I mean, I'm sorry. How would
you just said it too?
How would Attorney Hike know what Judge Bourne is looking at, not looking at, or whatever?
Well, a good point. You go, even my theory, it's bound to be.
Yes, how do you know what the judge is up to?
And I want to bring up one last thing as they come to mind. Needless to say, Eric Hike, I'm not going to say Judge Hike again. Needless to say.
There is a Judge Hike.
Well, there was, maybe that's why I'm saying it. Eric Hike, Attorney Eric Hike, after the February 15th hearing, needless to say, he felt like he was on cloud nine. Why he chose to engage with dialogue with Mr. Broussard out in the hallway is beyond me, but he did. And I thought it was going to go on forever. I went and sat on a bed. You remember, I said, oh my God, this is going to go on forever.
There's a part of me that likes Eric Hike.
I understand.
You don't like me, but I like him, he's all right.
So Mr. Hike says, now this is right after Judge Bourne has all but said, I'm going to pop you with attorney's fees till you ain't going to be able to see straight. Okay? That's basically what he said. I'm putting words in his mouth by my own admission, but he said, this is going to get expensive. I'm going to pop you. If you dare to amend this lawsuit and they re-urge the exception and I find you didn't cure it, I will pop you with attorney's fees from the outset of this litigation until that day. Do you understand me, Mr. Broussard? Well, needless to say, Mr. Hike was feeling pretty on cloud nine. And so he looked right at Mr. Broussard and said, let me explain something to you. The only way we will back off of attorney's fees is you have to drop both lawsuits. And I think that just might shed a little light into the fact that according to Eric Hike, Judge Bourne has looked at the other lawsuits. I sure hope that he wasn't trying to assist Eric Hike in strong-arming you into dropping the Lopez suit. If the two of them were, it looks like they failed miserably. Am I right?
Right, yeah, because, and I believe that's a conflict of interest, and I mean, even...
You said before that you think it's a conflict.
I told him from the beginning it's a conflict of interest, and if I was his client, Mindy Gerard and Melissa Dubrock, I would be like, don't use our case to negotiate another matter that's not our case. It just, so I believe that's a conflict of interest, but that's between him and his clients.
Well, and I think for better or worse, he's found out, Hike has, that those two are independent of one another, you know, and I'm not going to put words into your mouth. You can say for yourself whether you have any intention of dropping the Lopez matter.
No.
I didn't think so. All right, I want to thank everyone for tuning in. As I said, once we've had that April the 24th hearing, we will report back to you on what transpires. I want to encourage everyone to look at what documents we are going to present. Trust me, there are a bunch more documents. We're just giving you the ones we deem to be absolutely critical for this, most especially the memorandum, the opposition memorandum coming up for April the 24th. Hope everyone had a happy Easter, and hope you don't get too depressed having to write a check to the IRS today if in fact you have uncovered the fact that you owe taxes. If so, join the crowd. I can tell you that. I share your sympathies. So this is Robert Burns once again saying we thank all of our dedicated Sound Off subscribers and other site visitors. Thank you once again. We look forward to bringing you another Sound Off Louisiana feature in the very near future. Thank you once again.